Your Lordship, this is suspension of sentence petition where petitioner undergone 11 years and with remission it's almost 11 years notice.
Only 8 weeks.
Yes.
The offense is 306. 3 witnesses have been examined. All have turned hostile.
Later, if you ask me for extension, there is only please have. Applications have been.
Well, it's item 6, I beg to appear for the High Court, my lords.
Yes.
Pursuant to your lordship's orders, my lords, 3 things have happened, my lords.
अरे कहाँ चले गए भाई?
ये जज जो है ना, सुनिए
My judgment has been passed.
My lord, yesterday it was passed, my lord. He has been convicted.
that is
My
all.
lords, on behalf of yes, my lords, on behalf of the High Court, my lords, we have framed the SOP, my lords. It's been approved by the administrative committee yesterday. It will be circulated to the judges also, my lords. Also, his explanation has been called, and the matter, my lords, has been marked to the vigilance department also. by
He has
the
been asked
registrar.
to?
My lords, he's been asked to. The explanation has been called, my lords, in terms of your lordship's order, because my lords, the para also indicates that various dates adjournments were given, and the lordship said that the High Court has to, my lords, look into this, my lords. So therefore, apart from framing the SOP in terms of, my lords, para 2 of your lordship's order, my lords, the last line, last sentence,
Yes.
the explanation has also been sought, my lords.
देखिए approach the previous order.
वीडियो चल रहा है अपना?
Affidavit has been filed by the Registrar General of the High Court of Madhya Pradesh. Inter alia stating that the SOP has been framed and after approval by the AC1, Administrative Committee 1, it has been circulated to all the judges, indicating the fact that in what manner the correspondence in the matter of extension of time ought to be made by the judges working in the trial courts. First, we take the said affidavit on record. Next. Since, as informed, since the judgment has been pronounced, therefore, this application is now rendered fructuous, dismissed accordingly.
Grateful.
Please, Lord, we are seeking anticipatory bail. The accused Mr. Manoj Jaiswal, my lord, the only reason why the High Court has denied him the anticipatory bail is because he
So you have antecedent 302 case.
yes.
What?
My lord, it's a 30-year-old case. I've spoken with the family. It was some robbery that was committed in our home, and the trial has been pending for over 30 years.
Notice.
I accept notice on behalf of.
Lord, interim protection maybe.
I accept notice on behalf of state.
State. उनको लेते ना. So and so accept notice. On behalf of the state, therefore the notice is waived. Notice is waived. Service of the notice on them is waived. Counter affidavit will be filed within 2 weeks, 1 week,
3 weeks we have state.
3 weeks.
My lord, interim protection.
We are doing
So great.
in the meanwhile. The no coercive step against the petitioner with respect to case number so and so.
So great.
Please, my lords, it's a bail matter. My lords, it's our contention is the petitioner and the complainant were in consensual relationship. They were working at the same place, and even the annexure 10, which have additional annexure which are applied to files on record, it is they have communication. They were in contact with each other since 2022. Permission to serve to the state with the standing.
That will be sub, wait.
Much obliged.
Your Lordship, the petition has been made and accused on the basis of a statement of a co-accused. What has actually happened, there was a car in which the contraband was being carried, Your Lordship. That was found to be in the name of one Vaishnav. Much obliged.
Please, my lord. Your lordship, this is
Notice and term protection. लिखा है ना अभी?
hello.
Why you have filed here? Your application for suspension is pending. You see your LOD. You see your LOD.
Manoj, but there is no order on that, Manoj.
May not be the order, but the application is pending. Since
Manoj,
the
this
application
has
is
been
pending.
filed under that, Manoj.
No, you have
Nalsa
filed this
program.
application. I have 932 days. Even otherwise,
Manoj, this
the
has been,
first application was rejected 932 days. Against which you have come before us. Why we have to entertain?
Manoj,
You
may
can
I
go and file a separate.
Manoj, may I
But
just,
by chance, you have already filed that application.
Manoj, may I just say something?
Yes.
Manoj, this has been filed as a part of that NALSA program, Manoj, where the where the convicts are convicted more than half of their sentence and still, Manoj, the appeals
So
are
whether
pending.
this
Manoj.
program is not applicable to the high courts,
Manoj, that is there, Manoj.
you go
But
there and make a request.
Manoj, see.
Pragati, very clearly, we are saying once an application is pending for the high court, there is no reason to entertain this as well.
Manoj, may I just say, Manoj, High Court has not decided the matter till
May
now.
not have been
Manoj.
decided,
It
go and
has
make a
been-
request.
He has already undergone 9 years, my lords, out of 12 years, my lords. My lords, may kindly see.
May I
that.
ask you something different? Now you want to ask me something. What is the punishment prescribed and how the 10-year sentence has been directed by the trial court?
Yes, my lords.
20-year minimum is prescribed.
My lords are right, but that is under the
Don't
new
want
act.
to
my
say
lords.
much
The
more.
incident was prior to the amendment of the
We
act, my
see no
lords.
reason and come to it. Yes, miss. Dismiss until, we would like to withdraw, we are giving a chance to you.
My lords, this is by legal date, my lords may
Dismiss,
at least allow the delay, my lords.
dismiss everything.
But admittedly, the conviction is based on a lot of circumstantial evidences. There are no eyewitnesses. But more than 3.5 years of sentence, my lord, he has undergone. And your
Not the
lordship,
case, you go before the.
no, your lordship, my lord, just my lord, the High Court in para 7, my lord,
After
is
some
relied
time you
upon.
can remove it.
Only one request, my lord. May I point out one, my lord, aspect? But the High Court has relied upon the evidence of PW 7 Samadhan, my lord, stating that, my lord, there is a dying declaration. On the contrary, the PW 5, the first informant, my lord, if your lord, I just, my lord, invite your lordship attention to his evidence, which I have filed in the additional paper book. The PW Samadhan 7 Samadhan was not there. Kindly see, my lord, the additional paper book.
Dismiss. See no reason.
But, at least hearing may be expected. Your lord.
We can't do anything, everything. Go and make a request before the.
Well, another 5 years, as per my
We
instructions,
don't
appeal
know
may
what
not.
is there, what is not there. Yes, please.
Please, my lords. My lords, this is regarding regularization of a worker retrenched from service. It's in sheer disregard of.
How much cost has to be imposed?
No, my lords, kindly.
How much cost?
No, my lords.
Please
I
ask
will not
the
argue then.
concerned-
I will not argue, my lords.
How much cost has to be imposed in this case? 1 lakh?
No, my lords, kindly.
No, we'll do it.
I'll withdraw, my lord. I'll withdraw.
It is necessary. There is a judgment of. Yeah, judgment relied upon SLP dismiss against that. Now you are coming, taking every plea here against this poor fellow.
My lords, kindly just simply dismiss it.
Dismiss with cost of.
My lords, kindly reconsider the cost.
You see what is the state of Rajasthan doing?
You are going after a sweeper.
No, my lord,
What is this? Mighty state.
Defense?
may I just,
Because you have the panel lawyers, you have the standing counsels, so that you can come. The other side may come, keep it pending here. We'll go with equities.
My lord,
We'll not go here and.
kindly
anyway.
consider one point,
Keep
man,
this
just
question.
one point. May I just make one point?
You commence, your clock for cost will start ticking.
Absolutely. I'll,
Dismiss Randy. No cost.
my lord, there's a delay.
Delay condone. Dismiss.
Is it-
SLP dismiss.
Means my matter was dismissed without granting me leave to defend. The issue with regard to landlord tenancy is in question.
Absolutely not.
Means it is a
Nothing.
dispute which is there, minutes. That needs to be answered. But minutes, as far as today, minutes, the application is concerned, the application, the court has awarded, minutes, as a consequence of this, about 67 lakhs which has been awarded, minutes, at the interim stage. Because I was regularly otherwise paying rent to the MCD, minutes.
May I ask you something different?
Yes,
Like, court passed an order for deposit.
yes.
Like, then thereafter, on 17/4/2000, you filed this SLP on 17th of March 25.
Correct.
Then thereafter, on 17/4/2025, this matter was listed for the High Court.
Yes,
High Court observed that you have not complied the order.
that is correct.
Then,
But that is because of this order, minutes.
nothing, sorry, dismiss.
Because the amount is
So,
humongous, minutes.
if you want, you go and vacate otherwise.
You know, you go to that magic brick,
Yes.
find out the rent, what is the rental income? It is 6,000, it is 6,000 per square feet. And your area measures 600 square meters. It is 5,400 square feet. You know how much it will come? 5,400 into 6,000?
It was otherwise 800.
And what has been fixed is tuppence, peanuts.
But the person who is claiming that her title itself is in question.
Come to page number 74.
That is
7/12/1963. Then
Mr. Jain, it's not a case in which we should interfere. That is all. Finish.
I'm ready.
Delay condonation.
Delay is con.
Madam, we have condoned the delay notice issued. What more you want?
Much okay. Thank you.
But against the same impugned order, my lord has issued notice.
Take this one.
Keep your voice.
The parties have been residing separately, from last 5 years, there has been, she is even not even.
Only on the point of.
On the, yes, we're not, I'm not on the point of marriage because, they have been residing separately from last 5 years, there is no point of,
You are making this submission only. It will break down.
apart from that, even on the marriage, High Court have only considered that the dowry amount has not been mentioned correctly, which shows the discrepancy, which is not the case, there are specific.
Pressing on merits.
I do not want to, I am
What
only
you
saying,
want?
I am only saying, Lordship, consider, exercising, 142 for, the marriage has irregularly broken down,
Why
she does,
for a divorce?
they have been residing separately from last 5 years, she doesn't even want alimony, she's not even looking for any alimony, she's not even looking for any alimony,
All I will issue notice for mediation, nothing more.
Lordship may only,
Daughter is with the husband.
sorry,
Daughter is with the husband.
daughter is with the husband, there is nothing that she's even looking for. Your Lordships may consider, your Lordships may issue notice on mediation and your Lordships may consider, exercising,
Let us understand differently.
Malets.
You filed a suit for divorce on the ground of cruelty. That suit, that allegations were not found true, should dismiss. Came an appeal for the High Court, dismiss. Meaning thereby degree of divorce has not been granted. Now you are asking them to please pass an order, it will break down. Like, will not grant.
The difficulty is, prolonging this. She's just 33 years old,
Notice.
Get fine. Great.
No.
State?
Madhya Pradesh में let's Gwalior Madhya Pradesh में.
Respect to mediation.
Saying that if a girl child is born, the wife is asked to bring additional dowry.
That's what the allegations are, and there is specific even
Take this now.
That is
You can
and
get
the
a general-
learned judge says it is prevailing normal circumstances.
That's not the case, your lordship. I
All right,
do not wanted to press on. I do not wanted to press on marriage. I made a statement.
Mediation.
Unfortunate.
Go for mediation.
Very well,
Fine.
Lordship, I am for the petitioner, the identical.
I am appealing for
similar
responding
set
to
of
one
facts,
caveat,
Lordship.
Lordship.
The matter is pending.
Yes, state order.
Yes, so my lord, your lordships have seen, so your lordships, just one second.
Same identical as a petitioner Panzadi is concerned, he is also probation.
I am
Just
one second, let me
not
call for it.
consider Lordship. Identical matter, I am rank number 4 and the respondent rank number 12, Lordship.
Lords, may I submit?
No,
They
just
cannot-
let
the corporation submit first. They cannot seek parity with.
My lord, one second, my lord, may I just make one submission? I completely agree that this is, as your lordship said, it's the same matter on the probation act. First matter, correct, Panzade. Now, my lord, my only request was that either your lordship would consider restricting stay only to probation, because a general stay may not applies to across all categories. Like last week, your lordship took up the case of responsible officer, where your lordship said that this is subject to the outcome. So either your lordships may kindly say that any appointment made will be subject to the outcome of this SLP, or please may not confine the stay only to the case of probation and not to the other categories, because 4 categories have been decided by this impugned order. And last week, my lord, I just wanted to point out one other, because my lord was on the bench, but my lord, Mr. Arvind Kumar wasn't. This was the order passed in the other matter relating to.
I have ordered Mr. Bhatnagar.
No, my lord, Supriya Tapse, your lordship. Yes, I am showing the other one. Supriya Tapse, yes.
Supriya Tapse,
Yes,
I do have the order.
they're very well. Sorry, my lord.
You all that day.
I know that.
I remember everything.
Your lordship knows was it, definitely. So I was commending that order.
Lords, may I submit one thing, Lords? I am appearing for respondent number 1. Just one submission, Lords. They cannot seek parity with respect to Lords of Panzade's order entirely for the reason because Panzade had defended himself, Lords, in the writ court. Lord, they had chose, despite the service, Lord, they chose not to appear before the writ court. Straight away, Lords, because there was some order passed, Lords, in Panzade's matter, they come in, Lords.
One thing.
Yes,
In
Lord.
case of Panjare.
Yes, Lords.
The point was.
Yes,
whether
Lord.
the period of the probation can be counted for the.
Lords, may I submit this? It was not purely a probation, Lord. It was probationary training period. Lords, that's what Lords we try to be confused.
We'll
Lord,
consider it.
Lordship,
Right to
Lordship,
consider this.
no, Lordship will consider.
We'll consider on merit.
Second aspect is
Let us
this.
interpret
Yes.
issues.
Yes. Lords,
Right perspective.
can I make one more submission with your lordship's permission? There was one more aspect regarding 477 days joining period. There was a delay of 477 days joining period. Their own notification. Like, may I just point out another page number 184? Kindly come to page number 184 for a moment.
Anything else?
No, not. I'm just pointing out. Lord, that
Sorry, anything else?
Lordship. No, only thing.
File counter will consider.
Lordship.
Lord,
Yes,
please only consider saying the.
जो रेड फ्लैग लगा है वो order
Subject to outcome.
और tag कर देना.
Let it be subject to outcome. Lords.
I'm obliged.
We are
Your lordships are not passing the Panzade order or the other one.
Panjare.
But Panzade, my lord, is a general stay. So please confine it only to this case. Otherwise, my lord, it will affect other categories. That's the problem I am facing. That's my only concern. Please have a look at the order.
Other category case would come then.
Other category case,
If the other category case would come, then we will consider.
then it will be in the Supriya Tapase.
Supriya Tapase.
Yes.
Lords, let
All
it be Supriya Tapse's order be followed, Lord. May I request this, Lord, because Lord, let it be subject to outcome.
My lord,
let
can
it be let it be subject to outcome.
It is, my lord, just one, my lord,
Next
just one.
case.
No, my lord, just 1 second before your lordship.
Next case.
All right. Sorry.
Please, my lord.
You're okay.
I have Route 24 and
What
Route
is this
38.
compassionate pension?
So, because my lordship, the
You
Route
kindly
38
see
provided.
24. Come to Route
24
24.
is my lord there, and my lord, my submission is that Rule 38 and Rule 24 are independent.
No, nothing can be done.
My lord.
You convicted.
Because my lord,
Services
because my lord,
terminated.
my lord, very serious section of my lord,
Thank you
302
very
have been removed in appeal, my lord. My lord, since 1993 he was in service. He was.
4 months, 12 days. He was in service.
Yes, my lord.
And he is a primary school teacher, convicted
No,
for 302.
he was in a government school teacher.
Government primary school teacher, 302, convicted for 302, later converted into 325, read with 148, 149.
Yes, my lord, please.
He is the one who will teach.
I am only on the part of my lordship the pension because he's 58-year-old now. 2/3 is the my lord. Like the rule, they are independent to each other, my lord. The particular route 24 and 30.
Thank you very much. Thank you.
This case.
There is a my lordship delay in the matter.
You want condone or dismiss on delay?
Also, may it be continued.
Dismiss on both ground. Fine?
My lord, the delay will be continued.
No. You want to succeed half?
Please, my lord.
Half success?
At least, that is something, my lord. Please, my lord.
Delay condone.
In this case, the petitioner is before your lordship. I think for the second or third time.
Senior, you are.
What is this, sir?
Lord, may I just give me 2 minutes to just amplify this. Just 2 minutes, your lordship may. Just
2 minutes.
2 minutes, exact 2 minutes.
Like we'll count something
Yes.
for that payment for that 2 minutes.
I was expecting that. The problem is.
Problems are so many.
This is
Answer of every problem is not 136 now.
No, this officer was given a certificate of unimpeachable integrity by the High Court. Everything against him was quashed, but he was not given the post on a fraudulent statement made by the government.
Sorry.
Why inquiries against you?
He's also.
Why inquiries?
No. Those were all quashed by the High Court, my lord. He is the IO in those inquiries.
Completed inquiry.
And
Thank you.
Not after the SLP, can I make one small request? Lord? Sorry.
And it's senior, this is not a case in which
I'm not-
we will give you an opportunity if you want, but we'll start the clock now.
I'll not. I won't add in.
Somewhere we should restrict ourselves also.
That's why at the outset,
Every order, review, dismiss. Now you filed a new case and you want to say, get it revised, everything, because there is a fraud and fraud vitiates everything. Sorry, learned senior.
My lords, a similar issue is pending before my lords.
इसको ये वाले के साथ टैग करना, ये जो हमने नोटिस किया ना, इसमें ये रेड कलर का लगा है, उसको कर दे, है ना? नोटिस टैग दीजिए।
Obliged.
It's arising out of motor accident.
As per Panchayat Karmi scheme 3.5, the preference shall be given to scheduled caste, scheduled tribe and backward ballot. The petitioner is scheduled caste.
What is the interpretation made? Every card, whatever it is.
No, that's right, my
Whether
lord.
any
But
reservation-
first it is written scheduled
Please
caste.
kindly.
Yes, my lord.
Any reservation prescribed? Any reservation prescribed for this?
No advertisement, no.
It is only as per the rules, preference.
Yes, my lord.
So preference to the scheduled caste, scheduled tribe means, court interpreted, preference means two persons are on the same pedestal, preference you will get it. Nothing more. Dismiss. No case. No case, please. Delay convert. Issue notice on delay and realize on.
65 days of delay, my lord.
One thing is, we want to ask you, this is a case of a driver.
Yes, ma'am.
All right. After this amputation of your leg, what you are doing?
My lord, he is working with RTC only, but as a
Then
cleric.
you are getting all salary.
But my lords, he's not getting accordingly as a driver, my lords, and future prospects also have not been calculated. in this.
Maybe issue notice on delay as well.
Great.
But you understand now, there is no future loss of earning. You are getting the same salary, whatever you are getting.
No,
Now it is.
we're not getting the same salary.
Please file. You have not filed any
Difference of salary.
Show the difference of salary.
Yes.
If you were the driver, what you will get, and you were not the driver, then what you are getting?
We'll file on the next one. Great.
Dismiss, similar dismiss. Delay condone, all right. You must be happy by that.
My lord, may please. There is delay of 196 delay.
Following Order 9 Rule 13.
Well, what has happened, ex parte decree was passed and they challenged it by filing application under Order 9 Rule 13. It remained pending. The courts imposed certain conditions. They challenged in the revision before the High Court. Then after 4 or 5 years of pendency of this application, they challenged the original ex parte decree by filing a revision. Only question is of delay, my lord. After such a long delay, my lord,
I would sincerely seek for a passover. My senior is on his way now. He's busy in another matter.
Who is busy?
My senior, the arguing counsel.
No, are you not a counsel?
I am.
Say your senior is busy, we are free.
My lords, he'll just be here. Please grant us passover, my lords.
Yes. Nothing can be done. It's covered by Suraj Mani.
My lords, please don't pass an adverse order. He would like to address the bench, my lords. Obliged.
Fact that the landlord subsequently obtained vacant possession of a larger premises cuts.
How much time you want?
Given articles on credit. I have given articles on credit. I have to recover it from the market.
It will come, don't worry.
Till March.
No.
Till March.
March on. Which March? Over.
2026.
March over.
2020.
End of October.
December, Miller. At least till December.
End of October.
At least till December, Miller.
End of October.
December is not far away.
December is. Please. End of October. This is all. And you must be happy by that.
A lawyer has come all the way from Kerala.
That is why.
That is I cannot disappoint you.
Lawyer has come from Kerala.
Ernakulam.
But to assist you.
No, this
one. And the second is he has come to visit the capital of India.
Correct.
That is all.
Till December will be happy. Till December will be happy.
Mr. Chidambar is, you know, everybody have a desire to come in the capital.
Correct.
So he has come in the capital, nothing more.
Exactly. Lord, monsoon starts now. December will be the apt time.
What business you are doing?
November.
Hardware business.
What?
Hardware.
November, Diwali will go.
Obliged.
Fine.
Obliged.
November, condition business. Order, brother.
The Lordship, this is an MACT case. The accident happened in the year 2005, my lords.
Notice.
Grateful.
Lordships have seen the facts are not disputed. It's a pure question of law. Yeah. Because claim is under section 22.
It has been dismissed?
Yes. No. High Court has set aside the order of the trial court. Trial court appreciated it that the limitation for cross claim has expired.
How?
For this reason, your Lordship may kindly say the original claim, even in the counter claim.
No,
is
suit was filed on what date?
No, the suit was filed. No, I am not on the suit now.
You please,
I'll tell you, Lord.
come to that.
Lordship.
Suit filed on?
Lord, the registered sale deed. May I just
Suit
take?
filed on, sir?
Suit was filed on 29 September 2022.
Right.
And the first reply.
Summons was served on 1/12/2022. You don't have that, we have that date because
I'm not on.
We'll tell you the reason why.
Lordship.
Then come to the written statement was filed on 4/3/23.
No, that's true. 2nd February 23 is the first reply.
Correct.
And the counter claim is
Was
filed
on 27/20/24.
No, 31st of January 2025.
Sorry?
Counter claim is
No,
on
no,
20.
no. 27,
I stand
2024.
correct. I stand corrected. 20th July 2024.
Yes.
And the trial court passed an order on 31st of January 2025.
Yes.
Now the claim was that we, on facts, as I said, there is no dispute, 80%, 20%.
Limitation Act. Yes.
On 20%, offer was made that you purchase 80%.
Correct.
Or you sell your
Now,
20%.
what is your prayer in the plaint?
Lordship. Would your Lordship
Please come to your
section 44. So the prayer is that now that you are not prepared to offer it to me.
You are asking for possession.
No, I'm asking for partition under section 44.
Okay. You're also asking for possession, sir?
In addition.
Would your Lordship kindly see the prayer?
Yes, please.
Would your Lordship kindly see the prayer?
Yes.
Page 67.
Yes.
1 second.
Your Lordship may
One
find.
second.
Lordship.
You are not as fast as you are, sir.
I'm so sorry.
You are
I'm so
slow.
sorry. I'm very, very sorry. I'm extremely sorry.
Please come to page 67.
I'm on page 67.
Prayer B. Third
Yeah,
line.
decree of partition of the suit property, meets and bounds in favor of the plaintiff and against the defendants, we granted a decree giving the plaintiff free and independent possession.
Free and independent possession.
Lordship, is it?
Number one.
Yeah.
Number two, you are also admitting that you are not in possession
No, may
or.
I, sir.
Yes, please proceed.
Lordship, complete. May I only read 3 more lines, Lord?
Okay.
There. Because 80% I was in possession. Therefore, what I say, possession of the suit
80% of what?
Total, because there are 5 years.
You have 4/5 share.
80% I bought it.
Sir.
20%.
80%. You are in physical possession.
Lordship, listen.
How can it be?
Registered document. Would your
Sir,
Lordship?
you can't. Because undisputedly she is having 1/5 undivided share in the entire property.
Yes.
20%, yeah.
So you can't say I am in 4/5 possession of one portion.
May I only say this? May I just only clarify? Maybe I am not clear. 20%.
Absolutely clear.
No, may I only say? Would your Lordship kindly see only just 2 things? 2 things only, if your Lordship won't mind. 22nd July 2021 is the registered sale deed.
Correct.
Where
And you say 1 year.
a possession is given.
Yes.
20%.
You say 1 year.
Yeah.
You read
Therefore,
Article 97.
Lordship,
Please read Article 97.
my Lord, read with 22, my Lord.
When purchaser takes under the sale
Yeah.
sought to be impeached,
That's true.
physical possession of the whole property or part of the property.
Part of the property.
So now you, by virtue of your prayer in the petition, claim that you are asking for possession.
No reason and ground to
Lord,
it.
would your Lordship then permit me to raise all
Thank you, sir.
available contentions before me?
We are not denying for anything. We are only on the point of taking the counterclaim on record.
No, counterclaim, I have no difficulty, my Lord.
Take the bull by its horn and fight it out.
I wanted to avoid the litigation and therefore.
You wanted to coerce her to sell her 1/5 share because she is a widow.
No, I don't think so. I don't know.
No, it is.
No, if your notice is given, let them come. I am
How
prepared.
powerful you are. You have paid 2 crores.
Lord, would your lordship permit me to raise available contentions at least there? Lord?
There is everything before trial court.
Lord, would your lordship permit that? That's
Why should we? It is your right. You are
your right. No, once this is done, then the counterclaim is already taken on record.
Yes, but your written statement for the counterclaim.
So therefore, I
Counterclaim
may
is
be
a plain.
permitted to raise whatever legal contentions which are available. Only legal contentions.
Thank
which
you.
are-
Next.
Lordship, please.
31.
My lords, plaintiff's first suit was dismissed as per
What
under,
was the nature of the first suit?
my lords, the declaration on partition, my lord.
What is the nature of the second suit?
Ancillary relief, my lords, including partition and the,
Nothing doing.
oh, my lord, just
Seven,
adding reliefs, my lords, does not
11 only. Nothing doing. Sorry.
change.
No reason in Hogan.
I'm requesting for short pause, my lords. The arguing counsel is on his legs, my lords.
Are you not arguing concept?
My lords, I was suddenly instructed, my lords.
It should be a power of attorney. This advocate would be only proxy. This advocate should be adjournment counsel. This advocate would be of arguing. Is it a?
Sincere apologies, my lords. Sincere apologies.
Should I call the record of the file?
Sorry, my lords. Short apology.
Supreme Court Advocates on Record Association, Supreme Court on Arguing Counsel and Adjournment Counsel
Sorry, my lords.
for 2 years. Then you will become advocate on record.
Extreme sorry.
Never do that.
Sorry, my lords.
Sorry, thank you.
Great.
All I Passover. Passover. Come in, Passover.
33 also I'm requesting for a passover.
Which?
Item 33, madam.
No, for what? You make your submission, please.
This is the case
Okay.
Two wives. You are the second wife or first wife?
I am the second.
Second wife.
Why that's after
Your
7.
children, no, we want to ask you whether your children were made parties in the suit?
My children were made party, her children will also made a party in the suit. That's, I'm not disputing that, my lords. Today, the.
All right, notice.
That's made.
Huh?
Consider a stay, my lords.
Stay of what? They are dispersing the amount to her?
I have a disabled son also.
No, whether the amount is being dispersed to the first wife in its entirety?
No, 50%. 50%.
Like 50%.
Very well, I'll leave it to me.
Take out, there's one judgment, 2002, SCC 431. Rameshwari Devi versus State of Bihar.
Please, ma'am.
Yes.
Grateful.
It's AMA.
One case is more listed relating to the same. है ना? No, extension not. Connecting to the subject matter on both cases, case is listed. क्यों जोई? This one, more cases of this 34 relating. Thing. Let me clear in my mind. 35.
Yes, the adjournment you are here.
Worship said, matter may be disposed of. That's all what I want. What is my submission? Since it is pending since 2015. Counter rejoinder have already been filed.
Short prayer is made that a case of maintenance filed in 2015 of not being heard by the bench. First step, the non-grant of the maintenance may affect the review. Therefore, The case may be directed to be taken up at an early date. Full stop. The peculiar facts and circumstances of the case, we direct the Registrar Judicial to list the case immediately, and we request the judge concerned to please take up the matter and expedite the hearing. How much can you pay? What is the salary in these days?
8,000, your lordship.
Huh?
Driver, 20,000.
But come to page 112.
You are MCA.
The respondent, your lordship, the wife is.
You are also MCA. Both are MCA.
Your lordship, but I was working as a.
Both are MCA. Please don't say this.
Your lordship.
See your facts.
Your lordship, I was working as a driver.
Certainly you are working a driver. MCA driver means you know you will drive the
Your lordship.
big vehicle, computerized vehicles. So what would be your salary? Not less than 40,000.
Your lordship, yeah.
And you are only paying 15,000.
No, your lordship, I filed an affidavit of income in the family court.
Not filed, not filed.
Your lordship, the respondent didn't file it. Your lordship, the wife didn't file it. Ours has been filed, your lordship.
Correct, sir. What is the sin the daughter has committed? What is the sin your daughter or son has committed?
Your lordship, it's about financial difficulties, not.
Financial.
Not.
Suppose they were living together. You are living together. Would you not have maintained your wife and child?
Your lordship, but the wife is also capable of earning and was working as a lecturer earlier, your lordship.
You can disown the child.
No, not the child, your lordship. Not the child, we are, your lordship, but the wife is capable of working. She is an MCA. She was a lecturer.
10,000 per month.
Yes, your lordship.
It will come to 1,20,000 for a child.
Yes, your
In
lordship.
these days, child, what is the age of the child?
Sure. Child is
Minor son.
minor.
Minor son, about 8 years.
Yes.
As per the pleadings which I could get.
Yes, sir.
8-year boy, if he goes in the school,
Yes, sir.
how much fee is required to be paid for that boy? Then transportation charges, then
Your lordship, the only.
just please, then transportation charges, then all maintenance.
Your lordship, the only difficulty is my income levels.
Income, whenever,
My
whenever,
income level is the.
you know. Whenever there is expenditure, then the people enhance the earning.
Lordship,
There is no expenditure, so this is an expenditure.
Your lordship, that's not always
cannot
possible.
charge.
That your lordship, if it was, one wouldn't have difficulty. But unfortunately, in economic conditions, your lordship, it's not always possible.
You have to pay that of 10,000. Issue notice.
Indeed.
Returnable in 8 weeks. Full stop. Economy of interim relief. It is directed that the subject to payment of rupees 10,000 per month. The operation of the order passed by the family court shall remain.
Deeply obliged, your lordship. Deeply.
Pay 10,000.
Yes, your lordship.
First of all, we make it clear. In case of a default, this court may pass appropriate order for vacating the statement.
Lordship may notice 10,000 combined because it may be.
That's what we have said.
Yes, your lordship.
10,000
Combined.
in total. Whatever in total.
Obliged, your lordship.
My lord, petitioner is My lord, petitioner is complainant.
What is wrong in this?
My lord, that one is that
Is benefit of the Provision of Offenders Act is available to him or not? Please come directly on section 4.
But my lord, compensation is very less, only 2 lakhs.
Compensation 2 lakhs rupees award is less.
Very less, my lord, because one left eye side is
Certainly,
completely.
this is not a-
You are showing right hand and saying left
Oh,
hand.
sorry. Left.
Huh?
Left eye side.
The advocate is not supposed to say, do like this, do this, do
Sorry, my
that.
lord.
Huh? Well, what is wrong in this? 2 lakhs rupees awarded.
One,
Provision for a period of 6 months.
6 months.
So section 4 is applicable.
Yes, my lord.
How much you are asking?
One, at least 5 lakh, my lord,
At
because
least?
At least 50 lakhs,
5 lakh, 5 lakh.
5 lakhs.
Yes.
Okay.
Okay.
That the other side should come then.
The High Court under the revisional jurisdiction has reversed the finding of fact, Millards. And the finding of fact was, Millards, that it has not been established that the respondent has willfully neglected, Millards. And
6,000 rupees, you are running a photo studio.
Millards, no, Millards, that's wrong, Millards, because
What wrong?
Lordship may just see my income, Millards. Lordship, my income is only 7,000
This
rupees.
comes to the
And
question of
6
payment of maintenance to the wife or payment of expenses to the wife. Every husband will say, no, I don't have money.
No, there is a finding, Millards. She admits she is earning 6,000, Millards. Lordship may just see page 24, page 24.
You are a photographer. You know the value of the photographer in these days.
Millards, sir, it's a,
You yourself has admitted that I am a photographer.
yes, Millards.
We are
It's-
not
it's-
saying ourselves.
It's a dying profession, Millards, because everybody is having a mobile and a photograph.
Who says dying profession? Who says?
Millards,
You can
not
hire an
everybody.
engineer, but to get a photographer is difficult.
Lordship may just see page 24. She's earning, Millards. That's what I'm saying. Page 24, Lordship may just see. She's earning more than 6,000. She's earning more than 6,000, Millards, and she has also a land from which she earns, Millards.
Thank you, thank you.
There's a delay, Millards.
Delay you want to condone?
Delay may be con-
Condone. 50%. This shall be succeeded 50%. Lost 50%.
Millards, I have also a disabled sister to look after, Millards. And this is
First, look after your able wife.
great for me.
Thank you.
Please, my lords. My lords, may I humbly request. My lords, it's a matrimony. It has come out.
4,850 US dollar.
Merchant Navy.
For 6
Merchant
months, lord.
Navy.
For 6 months.
4,850 US dollar.
My lords, ma'am.
Merchant Navy.
In 2023, not in 2025.
My lord, may I humbly request something, my lord? My
You are
lord,
saying only 6 months.
no. I'm not saying lordship. I'm saying there are 9 matters among the parties. My lords may refer the matter for mediation.
Go there. Go sort it out there.
My lords, in the High Court itself, it was the mediation class. My lords,
If
that
we
is why
want to issue notice, we'll issue notice for enhancement.
my lords, may I
Are you
humbly,
interested?
my lords, we
Issue
have,
notice to the petitioner. Why? The amount of maintenance.
my lords, we are humbly going to comply with the order of the court, my lords, irrespective of anything.
During
Certainly,
mediation, pay more.
Certainly.
4,850 to 92 rupees for 37 paisa. Calculate it. How much it will come?
It will come more than 4.5.
Somewhere around 936,
Four,
around
three,
4
five
lakh,
lakh.
4 lakh, 4 lakh.
Like, we will ask you to pay 2 lakhs.
We'll certainly comply, lordship. No issues.
You pay 2 lakhs? We'll
Certainly.
record it.
We'll record you are ready to pay 2 lakhs rupees.
We'll do it. My lords, we want to explore this mediation process because our party was, this petitioner was willing to pay 60 lakh rupees. Respondent was asking for 80 lakh rupees.
Dismiss.
My lords, we are willing to pay.
Go there, go. In the
My lords,
court itself, you get it.
my lords, just one second. My lords,
Item number 40.
Office report shows the SLP differs against the same impugn order by the co-accused. My submission is I have undergone about 8.5 years, my lordship. And custody certificate shows there is no information. Benefit of the mission, ma'am.
नीचे लगाया order. Co-accused order.
Benefit of the mission may be given, my lordship, only submission.
Delay. They are in custody. Unload.
Highly.
Lordships, the High Court has issued notice but not granted a stay.
You will request the High Court to expedite it.
No,
High
Your
Court, the
Lordships,
matter is
no.
pending.
High-
1 second.
Yes.
Before the trial court, it
It's
is
on
adjourned to 17/7.
No, that is in one case. There are 4 cases. In 4 cases, 3 of them is for arguments On 20th of May, Your
No,
Lordship.
18/9/2025, High Court, the matter has been listed.
Yes, 18/9.
And before the trial court, it is listed on 17/7/20.
In one matter, there are 4 matters.
You-
In 3 matters, the arguments are listed next
Ask
week,
for
Your
adjournment.
Lordship.
Ask for adjournment.
Your Lordships may just, what happens, Your
Nothing
Lordships?
will happen.
Your
At the
Lordships,
most,
my
you will come in
difficulty-
revision
Yeah,
against the 138 conviction, if at all, if you are
this
convicted.
is my only chance of defense, Your Lordships. The High Court found
Even
something
otherwise,
in my case.
If
High Court found something in my
Madam,
case.
we can, if
Yes.
you want to make an observation, we can say section 73 of the Evidence Act.
Your Lordships may then, may I just say this? May I just say this? Your Lordships may just.
Going into a dangerous path.
Yes, your Lordships may then say this, at least your Lordships may
No,
record
madam,
my,
it is a problem to you.
no, that, see.
The High Court himself has observed like this. At the time when when the bank report was called for
Yes,
to look into, the trial court said no, the FSL is not required. We'll look
required,
into.
yes, that's what. Yeah.
Since the matter is pending before the High Court. However, we are not entertaining this SLP. First of all. However, we are not entertaining this SLP and made the request to the High Court to consider the application for interim relief
All right.
as expeditiously as possible.
And your Lordships may just record my statement that I'll make an adjournment request, your Lordships.
Madam, we are not saying anything.
20th, that's my difficulty.
Madam, you asked, you have come the order.
Yes.
You get a favorable order.
Your Lordships has given me something, so I.
We have already given you something.
You will get everything now. Don't worry.
I have filed the valuation, Your Lordships. I have to save my house residential. Your Lordship may see the difference.
Notice.
Stay also, because otherwise there is
In the meantime, parties are directed to maintain the status quo.
complaint.
Wait. Post of Welfare Officer Trainee Grade E1 is a direct recruitment post, my lord. The Honorable High Court erroneously thought it is a promotion post and held that the women reservation is not available. My lord, may kindly see.
This is not the internal promotion.
Correct, ma'am. No, it is not internal promotion.
It is
These
there.
are for only for internal candidates, but it is available to all those people from all the different departments. It is not, it's not a promotion post. May I show, my lords, the relevant rule, my lord, RRs. My lord, may kindly see page 101. It is starting from 101.
Yes.
Yes, RRs.
Yes, please.
These rules shall be called Singareni Collieries Company Limited Executive Cadre.
Where you are reading?
I am reading the very first rule.
10, the company policy.
Yes, my lord. Recruitment rules.
No, it is 101 you are referring now.
Page 101.
101 paper book or something else?
My lord, additional, sorry, I'm sorry, additional documents. Annexure P5.
Yes, please.
Got it, my lord. The recruitment rules, introduction. These rules shall be called Singareni Collieries Company Limited Executive Cadre Recruitment Rules and will apply to all employees of the Singareni Collieries Company Limited other than those personnel on deputation or personnel employed under contract.
Yes.
My lord, then 1.3, my lord.
You read that State and Subordinate Service Rules 1996.
Please, ma'am.
Why do you say Rule 22A2 is not applicable?
No, I am saying it is applicable.
This is your contention.
It is applicable. It is applicable in respect of direct recruitment rule, direct recruits, not in respect of promoters. That is what the Honorable High Court has held, my lord. It is applicable to direct recruits and erroneously held that these posts are the promotion posts. That is the problem. It is clear, my lord. If my lords have a look at reservations, 6A at page 104. It has provided for women reservation to women candidates. This is for recruitment of internal candidates, my lord.
Got it, ma'am? Page 104.
Yes.
Reservation. Selection will be based on merit, but recruitment will be made following the rule of reservation provided for SCs, STs, BCs, ex-servicemen, physically handicapped, and women candidates, in accordance with the rules of the state government in force from time to time, wherever necessary. Then, my lord, may I take my lords through part 2 of the rules, which is providing for different posts. Rules for recruitment from internal candidates at page 109, my lord. Page 109, serial number 3. Rules for recruitment from internal candidates. The following reservation is prescribed for internal candidates for recruitment at entry level in the executive cadre. The entry level at executive cadre. My lord, may kindly see 3 personnel, 33.33% E1. So out of all the welfare officer posts, 33 is provided for the internal candidates. My lord, then great.
My lords, the main council is suffering from a foot injury, so a humble request for.
No, madam, we treat you as a main council, don't worry.
My lords, I really apologize.
In our court, we treat you as a main council, don't worry.
We treat you as not only the, but also leading council.
It's a humble request, my lords, please.
What request?
Have you read the
Turn down. Turn down, request turn down.
Have you read the file?
Yes, I have.
No, please.
But my lords, I don't have the instructions to.
We are instructing you to go ahead.
We are directing, not instructing, directing.
It's along the lines of Suraj Mani passed by the honorable bench.
Yes, so.
But my lords, there's another issue that they are from an autonomous society and not a part of the state government.
But consequential benefits have been given.
Yes. My lords.
Issue notice, but delay condone issue.
Wait.
You don't want this?
No.
Dismiss. Okay, fine. From next time, come after reading more.
Lords, he's been inside Lords as an under trial for 6 years, 4 months now, Lords. Lordship, so please to Lords grant bail to Lords one request. Ambitious one, Lords. If Lordship can have it on Friday, Lords, I'll serve the standing council, Lords. Then Lords, immediately after reopening, Lords.
No.
That's a bail, Lords.
No.
Immediately after reopening, I'm saying.
It will come immediately after reopening.
Oblige. I'll liberty to serve the standing council. Oblige.
8 weeks. List immediate after reopening of the.
So this is the pension matter, and so we are find the mention this for the earliest hearing.
Let us on. Can we ask something?
Yes.
You have filed contempt petition.
Yes.
You are not a same subject matter. Similar directions were issued. You want to say it should be applicable in rem, not personnel.
Yes.
You were not a party in that case.
Yes.
How you can ask for contempt here?
But under Article 141, every court in the whole nation
All
is
right,
bound
go there.
to follow the
All courts will be closed. All individual cases.
every person is bound to follow the general
But
direction.
all the advocates should be closed then.
But this
They will also somewhere, nowhere. It's not a case of contempt.
This is a case of so please listen. They have Mandate has not shown the respect for the honorable court. This is the reason why. Please read the. I will take the 30 seconds only, sir. I would only read the FC of order of the FC, in which they have written that applicant has provided the rulings, but we are not. We have searched another ruling.
All right. Thank you. Thank you. We see no reason to interfere in the present contempt petition. However, the dismissal of the consent would not debar the petitioner to take recourse as permissible. We reject problem. Permission rejected.
Sir, dismissal withdrawn, sir. Sir, dismissal withdrawn.
Thank you for good, at least good self behavior. And that council after arguing seeks permission to withdraw this intent petition.
Sir, any positive order may be passed for that pension or maybe any order.
Positive order.
Any positive order which may help the petitioner to
Right. Dismiss as withdrawn. However, it is open to the petitioner to take the post as permissive. Next.
May it please your lordship. There were 39 members. Out of 39, 31 are ousted from the membership, and they were not even given an opportunity of hearing. I go before the High Court. I tell the High Court I was not given an opportunity of hearing. High Court says earlier division bench has passed an order against you, and therefore we are not entertaining that. Now the earlier writ petition was something else. What happened? There were 8 trustees who were suspended. They challenged that suspension order. Writ petition was dismissed. In the LPA, High Court says, ask the Joint Charity Commissioner to go and inquire. Please have a look at that order. Please have a look at that order which is read against you. Kindly have a look at page 109. 109. And at page
conclusion of this order.
Sorry, complete confusion of the High Court.
No, we are not saying confusion. Conclusion of this order.
Yes, that's what I'm reading.
Now, what is the conclusion of the order include?
In the appeal judgment,
remanding?
No, they say those 31 are ousted. So these 8 people who are remaining, they'll hold election. So those 31 will not be able to participate. Out in those 31, 2 are the founder trustees. They also go. So therefore, Milord, please have a look at page 111. See the drastic consequence. Out of 39, 8 remain and 31 go out. And that too without giving them an opportunity of hearing and on the ground. What ground? That is not even tested by the High Court. They say, the scheme was framed, a new scheme was framed in 2008, which required that you need to pay membership of rupees 5,000. These are members who have become life members prior to 2008. That's the order. And therefore, we say we have paid 251, then prevailing fee.
4 suspended members have been allowed to participate in the election.
No, what happened? Not both. What happens is this 8 members were there. Now, out of 8,
4 were suspended.
4 were suspended. That suspension is revoked. But what happens is there were 31 members from whom they were to elect the trustees. Now, those 31 members out. Therefore, permit me to show how it has gone ahead. Please have a look at page 111 first. That has been read against me, and I'll show those orders. It starts from page 109. This arises from suspension of trustees, where the LPA division bench in LPA passes this order. Page 111, your lordship may please see Roman 3.
Yes.
Yes. The concerned assistant charity commissioner shall verify the veracity of the list. Roman 3.
No
veracity of the list of. Sorry, madam?
No Roman 3 on 113.
Yes, page 111. 111. I'm sorry.
Yes.
That's the operative portion. The concerned assistant charity commissioner shall verify the veracity of the list of members and then shall take further steps to hold elections of Bankat farmers so and so expeditiously within after considering the objection of the said list. Now what happens is, now your lordship may please see the charity commissioner, assistant charity commissioner passes an order. That's at page number 112. Now none of 112, if your lordship sees, none of these 31 members are a party. 112. Now your lordship may please see page 125. 125. Yes, your lordship may please see the operative portion.
Yes. Let us see.
These proceedings started, your lordship, way back 2008.
Maybe started 20 years back even.
And my lords, one more thing, if your lordship just.
Let us understand.
Yes.
The charity commissioner order was the party.
Yes.
That order has been used against them. Can it be? Please answer. Can it be?
Milords, these orders were passed pursuant to the High Court order, Milords. Pursuant to the High Court order passed in LPA. And Milords,
it is returnable
the
in 6 weeks at this stage. So and so accept notice on behalf of On behalf of
2 and
respondent number,
1 and 2, my lords.
respondent number 1 and 2. In which case?
My lords, in first case, I am.
You are Shivaji Babu Rao
Yes, yes.
and Machendra Narayan.
Yes, my lords.
1 in so and so. इनका नाम लिख देना so and so. Should notice to other respondents. Other respondents. उनको लिख देना notice to them is waived. Notice be issued to other respondents. That counter affidavit be filed within the said period.
No, let there be a status quo, otherwise, status quo, whatever is present.
We say,
Otherwise, no,
we say,
otherwise,
again, that
My
the
lords.
proceeding, if any taken furtherance to the order, it would shall be subject to final
or
outcome.
you also may only issue notice on stay, that would be better.
No, no, my lords. See, he will.
That
file
would be,
an
otherwise
application.
what will happen is this.
Liख देना issue notice on stay.
Yes,
Nothing
that's,
would happen.
yes.
And the proceeding, if any taken.
No, that may not be avoided, that may be avoided so that what will
He
happen.
can't
is
have everything.
They'll take over, these 8 people will take over the trust.
Let them.
They can't do it, man. They can't do it if you actually see the operative portion of the order.
Nothing will happen.
You are there,
Clarification.
managing committee is 9 members.
No,
The
thank
8
you.
Very good.
Please, my lord, I'm seeking suspension of sentence, my lord, during the pendency of the.
Completed 9 year, 4 months.
More than 9 years.
9 year only.
Then-
It is not more than 10 year. You go and apply after some time.
My lord, very small time, I might remain
You
nine,
go and
more than
apply
I
after
might,
some
more
time.
than
9 year,
my.
1 year is too much.
My lord, kindly see the conduct of the petitioner is also in the court, in the judicial custody, my lord. He has
in the
received
custody.
2 appreciation, my lord, of the.
Yes, he is assisted in one person from escaping or prevented the person from escaping. That is the one.
You see,
No, my lord, actually, my lord, kindly see the background at least, my lord, he has widow mother, my lord.
The present SLP stand dismissed at this stage. Full stop. However, the petitioner is at liberty to remove the prayer after some time.
My lord, direction, if my lord possible direction pass to the, my
We are
lord, High Court
saying
to,
anything.
High Court to.
We have said
High
go
Court
and
to
get heavy liberty.
expedite the-
Sorry.
Highly.
My lord, adjudicating the case arousing out of 302, the High Court almost conducts a mini trial, my lords, question the,
Please understand.
my lords.
What was the role assigned to this man?
My lords, he was the person who was there, who was along with the co-accused and committed the crime. That's what the
There is
investigation.
no eyewitness.
There are
Case of circumstantial evidence.
yes, my lords, but the CDR,
Right.
yes, my lords.
Case of circumstantial evidence.
Yes, my lords.
Certainly injuries are there
Yes, my lords.
with the disease.
Yes,
This is right.
yes.
And total accused persons were
4, my lords.
4.
Yes, my lord.
All right. So initially the main accused probably that is different appears to be from that also.
My lord, as per the
So he is
investigation,
not the main accused. You can understand it is only the 8 months and 10 days. He
Eight-
was granted bail. We can understand.
26 witness, all of the same village, my lords, and they will, they are bound to be influenced.
Show notice.
I urge my lords to be the vacation immediately after the reopening, my lords.
Returnable in 8 weeks.
Immediately after reopening of next vacation.
My lords, by that time, they will have,
Grant of bail. We'll see.
may I have the liberty to serve the stand, dusty.
Take all modes, even by
Take
Twitter,
whatever.
WhatsApp,
Do it.
Twitter, Facebook, everything.
Oblige, my lords.
Yes.
May it please. I'll be left without any remedy, my lords. Single judge says a ground is, case is made out for grant of anticipatory bail, but is bound by another judge. The judgment refers it to division bench, but my interim relief, and this is invoked not in the FIR, not in the first. 5 days after I filed my bail application, SC/ST Act is invoked against all of that. Can't be, my lords, to defeat the right of a person under anticipatory bail. Now, assuming, my lords, SC/ST Act is invoked, what is the point, my lords, of going to, when there is a bar under section 18? The special judge can't decide anything. As far as the SC/ST Act, when it is invoked, my lords.
Only one question.
Sorry, my lords.
We can understand.
Yes, my lords.
The reference has been ordered,
Yes, my lords.
but you can apply before the High Court. Please, you have referred
I
this
did.
matter to the division bench.
We did.
So please pass an order
We
of
did.
and protection.
We did that.
Where is that?
The second order, my lords, page 16,
Page
16, 1/6, my lords. 1/6 is division bench.
1/6 division.
No, single judge, my lord is asking me, single judge. We didn't have, before division bench was the specific prayer.
Please, page 16 is before the division bench.
Yes, my lords.
Yes.
The single judge says I can't do anything because I'm bound by the earlier single judge bench's order, which I'm referring, my lords. Now kindly see, that's the incongruity, my
Mr.
lord.
Dave,
Yes, my lords.
Our question is not that.
I bow down, but he said that, my lord. That's the observation.
Like,
He said,
just please listen for a
sorry,
minute.
sorry.
You have single judge not said anything.
Yes.
Has come to the division bench. When
Yes.
the matter has come to the division bench,
Yes, my
you
lord.
can say to the division bench, please do this thing.
We did, my lords. Please see para 2. At this juncture, Manohar Reddy, senior, requests the court to pass an interim order, page 16, protection directing respondent not to take any coercive till the reference is answered. He contends that division bench has got every right to pass interim order even before reference. The division bench, my lords, then goes on to hold in para 4 at page 18, my lords. As such, the learned advocate contends that it's only a reference which the division bench can answer. Except answering the reference, division bench cannot do anything. So I am left neither with the single judge nor with the division bench, except your lordship's court, my lords. I don't have any option. It will become infructuous.
I appear on caveat, my lords, for the state. My lords, one very fundamental submission, my lords. Most recently, I reiterated in Munneesh, my lords, that they must disclose criminal antecedents. My lords may see page 32, what they've said, my lords.
You disclose, madam.
I'll just, my lords, their own election affidavit, my lords.
No, you disclose later, then we'll consider.
My lords, my lords, my lords may
You
kindly,
file the counter.
my lords may kindly hear me for 2
Okay.
minutes. My lords may just see the criminal antecedents, my lords.
Notice.
We have lied on already. My lords, my lords may have it. There are only 13 cases pending. Statement made before my lords. I am a law-abiding citizen with no antecedents.
Where is side so
Page 32, my lords.
of SLP?
Please, my lords.
Yes.
Ground 5, my lords.
Ground 5.
Yes, my lords. For that, the petitioner herein is a law-abiding citizen, having no criminal antecedents, and ready to abide by all conditions.
Now,
My-
where is your ground? You are saying that
My lords, I am on caveat, not in a position to take a ground, but documents speak for themselves, their own election affidavit, and I have the present
what
statement.
election affidavit?
You are a former MLA.
That's why the problem.
That
That's
is
why.
that is also the reason where you get the evidence to show that how
It's a
many.
double sword, my lords.
That is why the state on caveat. Otherwise, your lordships will issue notice, state will not appear. But today, because it's me, they are on caveat.
My lords, I am not.
No, it's not important. Important is where is which clause, madam?
Yes, my lords, at page 4, my lords, page 4, table 5A, my lords.
Page
4, table 5A.
Page 4.
My lords, at the
Table
bottom,
5A, yes.
my lords have?
Let's
Yes, yes,
see.
I'm so sorry.
I want it.
My lords, I have the present status also as of yesterday. I can handle. And my lords, SC/ST is one case. My lords may see the other allegations also. So to get off on a technicality, my lords. And absconding, my lords, we have served notices, never cooperated. My lords have also held that such persons are not entitled, my lords.
Mr. Dave, please, one, we are impressed upon one submission.
Lordship,
You see para 5, page 32.
page 32, my lords. Paraphrase.
For the petitioner hearing is a law-abiding citizen having no criminal antecedent and is ready to abide by all conditions. So this is a misstatement in the SLP, and on this ground itself, this SLP is liable to be dismissed.
But in my memo, my lords, on 129, my lords,
129.
whether I've disclosed, my lords, whether, let me check, my lords, whether
No,
I've.
my lords, we have
Okay.
checked, my lords, not disclosed before High Court. My lords can record my statement.
No, Mr. Dave, on this ground itself, it will go.
I'll check, my lords, kindly.
My lords, their
Mr.
own
Dave,
affidavit, my lords,
You are
want to check.
understanding what we are saying.
I bow down, my lords, but kindly see, my lords, I may only say, kindly consider it. This matter is for anticipatory bail pending.
We are not interested in that. We are interested, this SLP is on the concealment of the facts.
My lords,
Okay. You want we have to observe this?
Because I'm only praying, my lords, your lordships may just give me a chance to amend it and come back.
No, why we should give a chance like this?
Because this.
Suppose the other side would not be there, you would have get the discretion of the spot.
No, my lord, your lordship, they would have pointed it out, my lords, as
No,
far as this is concerned. I'm only checking
No,
whether it was disclosed at the
Nothing doing,
court below, my lords, as far as the criminal antecedents were concerned.
nothing can be done, sorry.
Sorry.
You convey to you are.
Why, no, don't attribute anything, don't take it personally.
No, I don't.
By using the strategy or stratagem, the party cannot take a snatch and order to. But for her, KBA, we were persuaded by what you said, because we believe in the advocates.
My lords, I was here because
On
he's
the
absent.
Madam.
On the point of law, your lordships were persuaded.
Might be, that's a different
But
issue.
I didn't say that there is no antecedents against me. That was not my
SLP
submission.
itself says that you have declared that you don't have.
Yes, yes, but in a regular form. Can I then, my lords, can I withdraw this and go back? I'll disclose it to the single judge, my lords, as far as some remedy, he'll be arrested. This entire reference will become, nobody will be there to prosecute the reference, my lords. Either one of the two. Lordship will not leave me in the lurch, my lords, as far as this is concerned. This is pure political vendetta. There's nothing less.
Whatever it is, we don't know anything.
I'm only praying, lordship.
Initially, you are of the view that there must be some respite. Initially.
I'm only praying.
But Mr. Dave, kindly listen for a minute.
Yes.
But you see, in such SLPs, in the SLPs and when the concealment of the fact is there, why we should pass any order? We should have dismissed such SLP.
My AOR apologized. He said.
No, nothing doing. Let him face. Let him face the consequence.
My AOR apologizes as far as.
Let him face the consequence.
So many times, my lords, when both either of the lordships are kind and generous, my lords, I'm only praying.
It's a great respect, it's a mistake on my
This
part.
statement has been made in the. We are not saying concealment, it's enough. The statement of the fact has been made in the SLP.
Can I withdraw it?
Indicating the fact.
My lords, can I withdraw the SL?
The petitioner is a law-abiding citizen.
My lords, can I
No
withdraw?
criminal incident. Inverted comma.
My lords, can I withdraw it, my lords? Kindly permit me.
Just wait, we are withdrawing.
Because
But
after
we
this,
mentioned this fact. No.
after this, I won't be able to
On
get
Mr.
anticipated.
Dave,
Lordship
for
also
this,
know
at
such
least-
vast experience your lordships have, my lords. I'll be rendered nowhere. I can't match your lordship's experience as this is. I'll be rendered nowhere. No court will touch me after.
We are nowhere.
After
Your
this.
experience is.
No, my
Just
lord. I know, my lord, both your lordship's experience. I'll be left nowhere, my lord. Not only in this case, in all other cases, my lord. Lordship, one word from your lordships are.
Okay, after arguing, council seeks permission to withdraw this SLP. Dismissed.
I'm grateful to your lordship. I'm grateful. I bow down.
So bring it to our next.
Yes.
My lords have given them a way to point it out, but I will not come in the way. My lords, I'm sorry for interrupting, my lords.
Thank you, madam.
I'm obliged.
Interrupting, you did everything and now you are saying sorry for interrupting.
I'm only sorry for interrupting, my lords.
Sorry to other side.
You have assisted us, you have done enough damage to him.
Yes.
Obligement.
Lordships are kind, my lords, not more damage than what is.
My lords,
I'm
too
grateful to your
magnanimous, my
lordships.
lords.
Thank you.
Generous. Obliged.
Next.
Grateful.
Go in High Court.
My lords, can I pray that?
Go in High Court.
No, my lords, I'll withdraw, my lords. I'm saying I'll withdraw and seek other remedies because there are some matters pending.
Yes.
Yes. So I'll
Yes.
withdraw, my lords. I'll withdraw. I will seek other remedies.
Go and take the notice.
Yes.
London Council seeks permission to withdraw the present SLP.
Writ petition also.
Present petition with liberty to take recourse as per the settlement of the law.
I am obliged.
Dismissed and withdrawn with the aforesaid.
Mr. Muldina, you go for a walk, morning walk,
I do, my lords.
where?
In my colony, my lords.
You just go to any of one or two parks, you will find out what is the issue.
That's what. So what they've done is they've got birth control rules in which they have earmarked areas of
Forget
feeding.
about birth control. If they come and bite you, what will you do?
No, that's exactly what we are also asking, my lords. That neutering.
What nutrient?
The rules are supposed to be
Small
strictly
children
followed.
will be playing in the park, they are attacked.
Correct, my lords. But if the rules are followed, that will not happen. In fact, if this is followed, it will not happen.
Thank you.
Wait, please, my lords.
Can I give a background of what has happened? Because I believe this is an abuse of process. And that has been allowed by the Honorable High Court.
What is wrong, by the way?
My lords, can I give a background? Then I'll
Can
explain.
give us a background, Mr.
Because it's important. What is wrong is, my lords, that a civil suit is filed by the predecessor in interest of the petitioner in 2010. That civil suit is decreed in favor of the predecessor of the petitioner in 2012. In that suit, the respondent herein was a defendant. She filed the same will that she seeks a declaration qua invite the amendment. She files that will. That is made an additional issue because she files it 2 years later. The trial court records that she has not been able to produce any evidence to prove that will. And the suit is decreed saying that the mother, who is the petitioner's predecessor in interest,
And the result is
yes,
the property has been divided one up.
50-50, exactly, my lords. Exactly.
Now, on the basis of the will executed by Bahadur Singh
Yes.
in favor of the Ashok Rani.
In favor of the defendant, yes. Respondent,
Alright.
yes.
I'm sorry, defendant means?
The respondent herein, my lords, the daughter.
Yes,
Yes.
his daughter,
Yes.
Ashok Rani.
Yes.
She is claiming now.
She is claiming now. She filed that will before the trial court. Trial court decides against her, my lords. That goes to first appeal before the High Court. High Court says the same thing. She files an application before the High Court. Allow me to lead additional evidence. That is also rejected. The decree is upheld by the High Court. That is upheld by this honorable court also. Now she yes. Now she seeks to amend, my lords, before the my lords, because now she seeks
It's required to be reverted.
because my lord she seeks to reopen title.
Nothing
It's a
can be.
matter for it to be adjudicated in the final proceedings.
But my lords, it's already been adjudicated categorically.
There is an issue. File your written statement.
My lords, I had
to.
the suit this suit, my lords, was filed in 2017. She filed this amendment in 2021. I have already filed my written statement, filed a 711 also because the main suit is not maintainable.
Thank you very much.
But my lords, it's already been adjudicated, my lords. This is why I'm saying it's an abuse of process. I am the real brother of the mother who died. She, my lords.
We are on that. Next.
Please, there is not a single allegation against the the old parents of the husband. The Honorable High Court issued the notice and but has not stayed the trial court proceeding which yet has to be started.
Go and ask the request with the High Court.
The court only in the order on the last line mentioned that
Arising out of an order.
then I'll withdraw the same or any just for it that it should be decided earliest because in this
After arguing, learned counsel seeks permission to withdraw this SL according to this. Notice कर देना. Yes, please.
State of Himachal. Sorry.
Which case you are appealing?
Not, I'm just checking. Sorry.
You are not aware even.
Not there are multiple matters. So I'm sorry.
Notice. Next.
I'm praying apology, my lord. First round, I am unable to there. I was in court number 7, my lord. I request my friend.
Ask. Can we ask one question?
Please.
You are appearing in this case?
Yes, madam.
Kindly see your list of tweets.
Yes, madam. Yes, madam.
What is the list of date?
List of dates I have annexed all
Nothing
the
is there.
but I have annexed all the documents. The content of the document I have mentioned. Page number E2, all the documents I have mentioned, description of the document I have mentioned.
Yes, please.
Well, here is the case, my lord. I'm only grievance, my lord. While filing the suit, they knows that I was a tenant.
Subtenant.
Subtenant. There is no prohibition in the agreement. There is kindly appreciate the property is trusted. There is no prohibition for subtenant. I was there from 1991 onwards. There is a sale deed for purchasing the superstructure. And moreover, after 2013, my lord, they didn't add.
You cannot get a better title than what your original tenant had.
Well, my remedy only lies, I have to file a suit or I have to file a contest the case before executing court. Two options available to me. Order 21, rule 27, order 20, order 21, 97 is there, madam. My prayer is here only. Till the 29. Till disposal of my suit, I may be permitted to continue because there is a eviction order staring at me.
Where did you file this application?
Madam, the first round I have filed before execution. Continue, madam. In the
You see, no region and down to the way necessary. Full stop. It is suffice to say that the observations made by the High Court in the order issued while deciding the application for injunction may not have any adverse impact while deciding the suit on.
Otherwise, no, I am ready to pay whatever rent fixed by this court because Tamil Nadu Rent Control Act is specific statute is there.
No, one thing is being said. First we picked up this figure, then later we start to pick up this hand.
No, it is not
Don't
like
go to that.
Publish.
Thank you. Item 31 is similar to this, same party. 31, no? वही मैं सोच रहा था So 9 months का लगा. Extension of 9 months is this thing. What is part? Who is for the petitioner in 45? Must.
Malach.
45?
Yes, Malach.
Yes, please.
My apologies, I am unable to appear through physically. Malach, I am seeking 1 week accommodation in this matter, Malach, for my personal difficulty.
Who is for the respondent? Nobody is appearing in response.
I am for the respondent, Malach. I have filed Wakaltama in this matter.
Who is appearing for the petitioner?
Malach.
Yes, ma'am.
What do you want, madam?
They have requested us in the morning that they wants to see.
Forget about that. You will have to make out a case for yourself.
Supreme Court is outside from the court. It is being run. Two advocates decided what we have to do. And the court will go accordingly.
Your Lordship is refusing an adjournment and I am seeking a passover, Your Lordship.
Who is your arguing counselor? Who is leading it?
In this matter, Senior Advocate Mr. Prabhakar leading in this matter.
Respondent is at counsel for the respondent is at liberty to fight. सो एंड का नाम डालिए हम रेस्पोंडेंट की तरफ से. So press for time to file. Color comment counter affidavit. List after so and so. Short term.
Much obliged.
Please, Your Lordship. There are 3 points which I will be seeking Your Lordship's permission to address arguments. First, my lords, that determination of landlord-tenant relationship has resulted in a finding that there was none. Secondly, my lords, the Supreme Court, my lords, time and again has, my lords, set out that's in the substantial question of law is a must, my lords, for hearing a second appeal. In this case, my lords, the parameters of substantial question of law having been framed are not met. And third, my lord, the suit was barred by limitation. My lords. It was beyond 12 years. And all 3 points.
Mr. Jain, can we ask one question?
My
To
lords.
finish everything.
My lords.
Are you interested in some time?
My lords, but in this case, my lords, this particular case, my lords, the landlord, the alleged landlord, the property which he is showing, the evidence is to the effect that it is not the same property which is in my possession. So there is a complete mismatch, my lords, with regard to the suit premises.
Go with Executing court, go there. Otherwise, we are dismissing this, not granting any time, you go there, all raise of the objections.
So your lordships have asked
No,
me.
no, this is not a case.
No, your lordships
This is
have
not a
asked.
case in which we should interfere.
Then my lords may, I suggest my lords, my lordships may re-notify it. I will take instructions and also will try to work directly with them.
No, we are keeping Passover, you seek instruction.
My lords, it may not be, my lords may have it next week. It's not that I'm.
No, it has come now, it will be decided. You understand now?
We have applied our mind.
Yeah, your lordships have indicated your lordship's mind, but what I am submitting is that, my lords, let me at least speak, because we are since 63, my lords. Now it's about 62 years.
This is why.
Yes.
That is why.
So, my lords, let me, my lords,
Passover, Mr. Jain.
let me advise the client and let me.
Passover, nothing more.
Your lordships may kindly have it on Monday, my lords.
No, Mr. Jain.
My request is
No.
that.
It will be today itself. Today is the best day.
All right, my lords.
Yes.
Yes, Raj. May I please, Your Lordship?
My please, my lords, seeking a short pause over, my lords. The arguing council is held up in court 6 item 15.
I'm ready with the matter.
Passover.
Because you pass over. 49.
Passover.
Yes, Mr. Giri.
Mate, please. What do we do?
You are in vacation mode?
No, I am not.
Everyone is in vacation mode.
I've been trying my level best to see that the matter is taken up. There is an interim order operating against me. That's it.
All right.
As your lordship.
Your lordships had an item 50 on the 21st of February issued notice. Service was complete as per the office report, my lord.
I am for respondent number 3, my lord.
Insurance company has entered appearance.
Notice was issued on the delay, my lord. There is a delay of 533 days, my lord. Kindly see the page number 1, my lord, the impugned order.
I'll remind your lordship, the notice was issued because at page 50, the insurance company shows the wrong policy to the Labour Commissioner, my lord.
That is not the issue, my lord.
That is absolutely,
they have been
please see page 50.
They have been proceeded ex parte before the tribunal, my lord. They filed an appeal against the ex parte order, my lord. That has also been dismissed. And the petitioner is the employer. Insurance company has no liability fixed by my lord.
I have
now
deposited
before
on
this
your
court, my
lordship's
lord, they are trying to shift their liability.
Certainly there can be.
My lord, yes, my
It
lord.
can be,
No,
if it is possible,
not at this,
possible, it will dismiss.
not at this stage, my lord. Kindly see the page number 1 of the impugned order, my lord.
1.
Please.
Yes, page number 1 of the impugned order.
Para 2, my lord.
Yes.
petitioner have approached this assignment of the order dated 26 December 2009 passed by the Workmen Compensation Commissioner oblique Deputy Commissioner Prayagraj, thereby rejecting the prayer of the petitioner to seeking the ex parte award dated 16 September 2018, my lord. Now, my lord, kindly see the page number 2.
Yes.
It is stated that against the ex parte award of the petitioner has moved an application under Order 9, Rule 13 of CPC for recall of the ex parte award dated 16/9/2018. It was stated the person, namely Sri Pawan Timari, who was doing purview of this case behalf of the petitioner, had left his own after which no one appeared before the Workmen Compensation Award. My lord, kindly see, this is a private limited company, not a single petitioner he was. And he was the employer, he was the owner of the truck, and the policy was not exhibited document. That is the policy. They are claiming the policy, the vehicle was insured in 2014 to 15. That policy was not exhibited. They never filed before the commissioner, my lord.
So, but those policy was in vogue or not?
My lord, I'm not claiming that policy was not.
Where is that policy?
Page 20, my lord. The insurance company, albeit ex parte, if my friend, for instance, in this matter had not appeared, surely I would not have an excuse to make a misstatement before a judicial officer and say that a subsequent policy is the relevant policy. Page 20, my lord, this is the first policy which was in vogue on the date of the incident.
So this policy, under this policy, they would cover up.
It would cover. What my learned friend's client showed is the policy.
Have you answered this issue?
My lord, at this
in your
stage,
counter affidavit?
My lord, we have not filed counter. Last.
Would you like?
Please, my lord. Please.
I'm extremely obliged.
But my lord, apart from the,
Let them.
I'm obliged.
Apart from these, my lord.
We'll consider. Don't come on technicality.
Sure, my lord. Please.
I would request that the delay be condoned.
The net counsel for the respondent. The petitioner submits that the policy which was in vogue on the date of accident has been filed at page number 20 of this SLP.
Please.
20 and 21 of this SLP.
Please.
Full stop. The net counsel for the insurance company prays for time to seek instruction and to file counter affidavit. Needful be done within 6 weeks.
On delay application also, my lord.
My lord, delay may be condoned.
No. I will file the.
Today you find the reply.
Please, man.
I'm obliged.
Please.
Not today. Delay we will consider, we will look into what can be done.
Please, my lord. I'm obliged.
54.
Right, please, your lordship. Your lordship, in the last hearing, my lord,
This is
directed
that
the
case.
respondent, my lord, please.
Have you deposited the amount as directed by this court?
Neither deposited, my lord, nor filed any reply, my lord.
Have you deposited the
Your
amount?
Lordship, the council is appearing Your online. Your Lordship, I appear for the respondent in this matter. Your Lordship, the order passed by this court has been communicated through all modes to the respondent. However, we have not received any instructions, Your Lordship. I leave it to Your Lordship and also permit me to discharge myself from this case, Your Lordship, because we've genuinely sent through all. My AOR has the application, Your Lordship. We will formally move an application if Your Lordship permits.
We can learned from AOR appearing on behalf of the respondent submits that the order dated 29/4/2025 the order dated 17/12/24 and 29/4/25 has not been complied with. Full stop. The respondent is not in contact with the counsel appearing or him. Full stop. Therefore, bailable warrant be issued. Bailable warrant of sum of rupees 20,000 be issued against the respondent for his appearance before this court and to show his compliance and to show the compliance of the order dated 17/12/24. List on so and so date. Fix. Bailable warrant. In the said warrant be served as such of the concerned police station for his appearance before this court.
Warrant.
I'm grateful, Your Lordship. Grateful, Your Lordship.
My lord, the same way, my lord, in the earlier occasion when this court directed, my lord, the council same way submitted before your lordships not getting an instruction, my lord. Again, today also submitting the instruction, same way, my lord.
That is an art.
That is the art.
Lordships will be formally moving an application.
My lord, the warrant may be executed through the consent the inspector of police or something. Sometime they may.
What we have said, we have not heard.
My lord, much
We dictated in English. only.
Much obliged. I skipped, my lord.
Gratefully, Your Lordship.
Gratefully, Your Lordship.
Much obliged.
55, my lord, as desired by your lordship, my lord, it has been settled.
Matter has been settled.
Yes, my lord.
What are the settlement terms?
Now, my lord, the total amount which is required to be paid is 48 lakhs, out of which, my lord, 5 lakh is already paid on 7th May. And, my lord, 10 lakhs, my lord, we are paying today. And the balance 33 will be paid on 21st of May, my lords.
21st of?
This month itself.
21st of?
Yes, my lord, 33.
This case on 22nd?
Yes, my lord. Yes, my lord, your lordship may have it on 22nd.
Well, the request is there are a number of other cases. If it can be disposed of under Article 142, then in that case we need not go to
Let's first pay the amount.
outline.
Like, then we'll consider we are fixing on 22nd of May.
Highly obliged.
Money should start flowing, then only.
Yes. Yes.
No, my lord,
Highly obliged.
one of the conditions is that he will withdraw all the litigations before 21st. So, my lord, that may be done.
Likhe, the settlement has been decided between the parties. However, for compliance of the terms of the settlement and to report such compliance,
Yes.
this is the case
Yes.
on 22nd.
Yes.
We are not saying anything.
Yes.
We are saying
Yes,
report the
please.
compliance.
Yes.
Was the payment of 10 lakhs is recorded? If the payment of the 10 lakhs.
10 lakhs to be paid today, my lord, we are just paying it.
Report the compliance. They give it whatever you want to give it. 56.
Please, my lords. He had to, my lords, quote a figure.
Yes, lordship,
I had
we
to
have
only
checked
submit,
up.
my lords. I had to only make a submission, he had to quote a figure.
We have checked up, my lord. The market value is 19,000 to 20,000 maximum per square feet. Whatever your lordship will decide.
My lords, I have a
That we have
suggestion.
ascertained, we have a certificate as well.
My lords, I have a suggestion to make. I am willing to buy because these are 6-8 people living in the quarter, 12 pieces, my lords. I have a suggestion. At 25,000, I am willing to take as per the plan that he has for others. Because they are large complex that he's building. So he's saying 20,000, 19 to 20,000, I'm willing to take an extra space in that complex. He has very much vacant space. At 25,000, let him give me 500 square feet. And
Can
more-
we ask one thing?
My lords, I can only.
Very attractive argument. Very attractive argument.
My lords, I'll tell my lords as to why.
No. It's very attractive argument. If you are so competent and purchase this everything, why you are asking for that much?
My lords, because under law,
He can
33A7,
He can-
33A, my lord, under 33A7, he has to give me 300 square feet, my lord. I'm so sorry.
We
my
can
lord.
understand everything.
My lords, may.
Everywhere we should be reasonable somewhere.
My lords, I'm. Ready and willing to purchase it for 25,000. All right, we'll ask him to pay 25,000. Lords, it is 10 square feet, my suggestion, and I leave it for my lords to. 10 into 10, that is 100 square? 100 square feet. 100. My lords, what I'm suggesting is this. If my lords said 19 to 20,000.
It is 10 square feet, not 10 into 10, my lords.
Please, per square feet will translate into.
Because of 140, as per your plan,
My lords.
sketch plan, probably these apartments is of 140 square feet.
Yes, my lords.
So court order is 150. So you say that for 10 square feet, we are ready to compensate. 10 square feet.
140 I have already offered them.
Yes.
So what remains is only 10 square.
Yes, my lords, that is only.
So for 10 square feet, you want to pay the money. You are saying 19 to 20. They are saying they are ready to purchase in 25. So we said 25. Pay 25, finish it.
My lords may give something extra and I leave it for my
Anything
lords.
else?
That is the extra. Extra, my lord says. What can we say, my lords? Every day we have to submittances. My lords may give some extra. They are poor people, my lords. We are
What
against-
poor?
We are capable.
Who are
I'll tell my lords the capability.
Go to me, my
The
lords.
capability, I'll tell my lords. The 10 people who have to pay investment linked plan, my lords. It will take.
Let this would be a development. Like you get the amount also, you get the
Premises.
apartment also, premises also.
If
So please, there should be a development. Don't put a
I'm
hindrance.
not putting an end. He has some other matters pending. It will take 5 years to develop. We can organize that money within 5 years. If he's giving it to others at a particular price, he gives it to us, we can
We
have.
will not do this. We will
I'm
not do this.
I am just suggesting to my lord.
So we have asked,
Trying to
what
find-
may be a term you want to say? We have asked yesterday you,
No, no.
please give the terms in which you want an order.
Can be disposed of in that terms. So far as agreement is concerned about permanent accommodation, there's no difficulty, we'll execute that. We have done that with others. Similar arrangement will be made for him, there's no difficulty. We'll pay him, say, within,
We had to file that agreement, I think. He had
we
to
will
file
pay
that-
him within 1 or 2 weeks, there's no difficulty about it. But only one small request, my lords. On receipt of payment, he should vacate immediately.
No, he has
We
to
can
give
proceed.
permanent alternative accommodation. till
We'll do
such
that
time-
everything within that, my lords. Once we do both the things, pay him and execute
Just
the
please,
document,
one by one.
my lords.
Within how many days you will offer them accommodation? First, you have to give the offer for accommodation.
Alternate accommodation registration within a week.
Within a week, my lords. We also-
Alternate accommodation.
Yes, yes, within a week.
You will shift him within 1 week, alternate
He
accommodation.
says 1 week, not your lordships may have it on safer side on 2 weeks. We will, no, my lords. But the arrangement is in terms of rent, my lords. Arrangement is in terms of rent.
Rent, how much you will pay?
That is 5,000 is being paid to all others. Similar
Is it
will be to
right?
him.
I don't.
Because I have the agreements with me, there's no difficulty.
Agreement says.
I have the
Yeah.
agreements with me, my lords.
Agreement
Lords,
has
want to
paid
peruse, I can
68
tender it across the bar.
of the SLP paper book does not say that at all, that he'll pay me 5,000. He's to give me an alternative accommodation till such time he develops. Suppose he does not develop for 5 years, my lord. Where does a poor person go and live in Bombay with 6 to 8 persons with him? That is how the arrangement works, my lord.
For other tenants, what have you done?
My lords, we are same thing, my lords. We are paying them.
Accommodation given or 5,000?
No, it's 5,000 given. Rent we are paying everyone.
This is what the.
So there's, well, this actually, my lord, this is compensation towards the alternate arrangements. So the alternate arrangement they have to make for themselves, and we are paying them as a compensation 5,000 rupees per month. We have been doing that for all others. For him also, we'll be doing that. There's no difficulty at all, my lords.
Page 68 is the agreement. My lords may have a look. SLP paper.
Page 68. Yes.
And nothing mentioned about 5,000 rupees. In fact, how it works is this. The builders give alternative
From
accommodation.
where you are saying 5,000 giving? Mr. Deshmukh?
Lords, can we only for a minute, my lord? This is. Well, oh.
What is the present accommodation which he is occupying?
205 square.
Your lordships come to, my lords, paragraph number G, page
105
70.
205, my lord. 205.
Page 70.
Page 70.
Yes.
Page 70.
Yes, please.
Lords, there appears to be some difference in the document.
Different document.
That's a different document which is placed on record. The one which is registered and I have, if lordships want, I'll place this on record. It specifically mentions the developer will be providing a rent of 50 rupees per square feet on existing area, that is rupees 5,000, and
This is
aggregated
entered
to
with
rupees.
whom?
This has been one of the tenants, my lords, and
Page 68.
and the name is Khimji Patel, Rajesh Khimji Patel.
Page 68, which I'm referring.
And the
to, my
document is
lords,
of
for my
13th of
lordship.
November 2024.
This document they are saying wrongly filed.
No, my lords, I'll give the copy of the document. Page 68, my lords.
What is this document?
This document is agreement for providing alternate accommodation to the tenant.
With you, this is executed with you?
No,
No, this is
I-
one
but
Mr.
the tenant-
Dharmendra Joshi.
Let me housing with Dharmendra
But-
Maharaj Joshi.
Because
The tenant's name is there.
raising the premises, so he is not eligible for the rent. That's what.
So the explanation, my lords, which on instructions I can say is, he was not entitled to a permanent for the rent. And that's why this document doesn't refer to rent. This Mr. Joshi. And the others who are who are otherwise entitled, their my lords, we are paying this document. Your lordships may have it, my lords, in next week on any convenient date. I'll place these documents on record so that your lordships will have a complete holistic picture of this.
List next week.
My
at
lords.
the request of the respondent.
My lords.
They are permitted to file the additional documents.
My lords, I'll do that.
Both sides, my lord, the additional documents. My lords may have it on Wednesday or Thursday.
Additional documents.
Can it
But
be on?
do
My
it
lords. I'll do
unnecessarily
that. I'll do that, my
keep it
lords.
pending, otherwise
I'll
it
do
will
that.
go in lapse.
I'll do that, my lords.
Wednesday or Thursday.
Next week में लगा दीजिए.
I'm grateful.
My lords. Publish lordships.
Yes, Mr. Jain.
My lords, my learned friend tried to speak to the council there. He has not been able to, my lords, contact. So then, my lords, we are left with, because we are not in a position to, my lords, indicate as to how much.
All right,
Because in
take
fact,
it Monday.
2 weeks back also, your lordships had told Mr. Mishra to take instruction on this specific question. Your lordships will recall.
Okay.
I have no difficulty.
Why we have last chance on the way of on the request of Senior Counsel Mr. Jain. He list the case on Monday. Monday की date लगा दीजिए. First of, he is at liberty to seek instruction in the matter. Otherwise, appropriate orders will be passed through.
Grateful.
Grateful.
None appears on behalf of the parties. Stop. 48.
Maybe
Yes.
next week, yeah.
Next week,
Maybe then after vacation, some personal problem.
vacation will not be.
Great.
49 now.
Directly to be listed on a non-miscellaneous day by order of 17th March.
That's okay.
Hmm.
But thereafter, the matter was, it come up several times. If you had
But
subject to your
has
lordship's
it
time,
Come up now, after.
I'm
17th
saying
March.
after that, it had come up several times.
No, it has not. 17th
With
March.
regard to the width of the road.
That's correct, my lord. I have a problem. This entire construction is held up because of this. And they have no
All I'm
dispute
saying
on
is
the
there is an order
construction.
directing this.
The
matter.
only
As-
dispute now is the width of the way and the arch. The width of the way has been found by the Taluk surveyor on a report after the remand was made by this honorable court to be 6
Right,
meters.
you want on NMD?
But I'm already.
Tuesday, next Tuesday.
Very much.
Next Tuesday. You may make a request on that day, Mr. Giri.
Yes,
We'll look into.
very grateful to you.
Next Tuesday.